Every day in the USA, people find themselves in court.
That's yours, David?
Yes, sir.
I don't remember placing you on probation because I remember that name. How do you pronounce it? Just like the Native American or, okay. Let me ask you, what's your middle name?
Middle name, Jay.
Okay. Didn't know if it was another Native American, honoring the Native Americans in some way. All right, you have a motion to revoke unadjudicated probation that was filed back in February. Why have we taken so long to get here? This is a state F felony. You've got 9 violations here that have been alleged. 9. Why did it take him? He wasn't an absconder or anything, was he?
Yes, sir, he was.
Oh, he was?
Yes, sir.
Oh, okay. Well, okay. That
He
makes
had pending charges in Montgomery and Chambers County, and since being apprehended, those have been resolved.
what's been revoked.
He served time in
Did he
Montgomery
have
County.
probation?
He had
in
probation
other
in
counties?
Chambers,
Okay.
and the alleged violations in this motion were the offenses in Montgomery County.
Okay, well, he pleaded true to those or something?
Correct. Yes, sir.
All right. So what happened in Montgomery County?
He served 60 days in the Montgomery County Jail, and then he served 150 days in the Chambers County Jail.
Okay. So you're out and you're now before us, you're looking at a state jail felony, no less than 180 days up to 2 years in the state jail. Do you understand?
Yes, sir.
Is there? What's the restitution on this here? $426.20 originally? And is there still restitution outstanding on this?
Yes, sir. As of today, the full amount, $426.20.
Okay. What are we gonna do? It's
Can he pay it?
he's got 9 violations to answer to.
I know, but can he pay it?
That's one thing. I don't know. Well, you want a hearing on it?
No, sir.
Because there's 9 violations. We don't have time to have a motion to revoke probation hearing. Is that what we were going to do today? Is that the plan?
No, this is just an announcement, Judge.
Because it's going to be set for hearing. I want to hear, and he's going to be answerable to me on this. This is a mess that was made on my watch, and I don't like it. No, you don't get put on probation and then go out to other counties and commit crimes and not take care of your responsibility. In this case, was the person who was injured is owed money, and not one dime has been placed on that since you've been on probation for over 2 years, sir. You're going to be held accountable to me and the victim and the people. This is irresponsible. We put you on probation to warn you, and then you really made a mess after you were warned about we were going to be dealing with it in a responsible way. I see 4 different crimes committed. Would y'all be ready for a hearing? I want in 5 weeks, okay? 5 weeks.
5 weeks, should be fine.
Get a resetting. And anything else that fouls up, we're going to add that to the list and deal with it then too.
Yes, sir. Understood.
Because you've run out of rope with this court. Evan Jones. 3 cases?
Yes, sir.
And you too, buddy. Where's your rope?
Pardon me?
I'm gonna get you a special little new rope for Christmas so that you can have an extra lifeline. Like here, you're always He's pulling up from the side of the mountain, but you can always get up to the top. Oh, Kevin Jones, where's
He's
Kevin?
in custody.
I need him, please. Thank
Yes,
you.
sir. I'm trying to get up to my.
This is sentencing hearing, right?
Yes, sir.
That was bad luck to be called after that last guy.
Yes, sir, it was. It really was.
You know, then what? Go figure. Go figure. Was Kevin better or worse than that last guy? He's better.
Better,
That's your answer.
better.
All right. Who's the secure on this one?
Mike.
Mr. Laird? Where'd he go?
Oh.
Where'd Mike go? Laird.
He's right there.
Didn't I see him?
Mhm.
What time? Can you figure out?
Yeah.
Time credit, please.
Yes.
Kevin Jones. Yes. How's the party going in the back?
I was dealing with another legal matter, Judge. I
Oh,
promise you. I
okay.
was.
I thought y'all started Christmas party early, maybe. I wasn't invited,
I'm sorry.
and Godwin said he didn't get an invitation.
I wasn't inviting him.
Tough crowd today.
Tough crowd.
Tough. All right, we have two cases. And actually, we've got three cases. Two of these are new.
Yes,
Then we have the older case, which is the motion to revoke probation.
yes, sir.
This is sentencing.
Is, yeah. Looks like the defendant has pleaded true back in November, last month, to committing the offense of assault causing bodily injury. And this is the assault that is alleged in this indictment, 24 CR 1331, the third degree felony of assault, family violence by choking.
Yes, sir.
He didn't plead guilty to that substantive
No, sir.
charge.
Not
It's
yet.
just true to the allegation number 5 in the second amended motion to revoke unadjudicated probation in 31029, correct?
Correct.
All right, we had I ordered, and the probation office was kind enough earlier to have a
Yes, sir.
a pre-sentence investigation updated report on the defendant's issue of revocation in this case, which was dated November 22nd, 2024. Have the parties had an opportunity to review that report
Yes, Your Honor.
Yes, sir, Your Honor.
and any corrections or changes to it?
No, sir, Your Honor.
Not from
Then
the state.
It will be made a part of this case for all purposes of sentencing.
Yes.
All right, the defendant is looking at a second degree felony of aggravated assault with a deadly weapon. So he's looking at no less than 2, no more than 20 years confinement in prison and a fine up to, well, fine is not really relevant here. And the indictment that the defendant was on probation for this aggravated assault included the use of a deadly weapon, namely an automobile.
Correct.
All right. That wipes out regular probation as an option from this court.
Yes, sir.
All right, I'm going to allow people to summarize what your positions are. State can go, then the defense, and then the state can offer a rebuttal if necessary.
Judge, Mr. Jones just has a history of abusing the women he's in a relationship with. He just, even while he's on probation for one offense involving one, he's committing another offense involving another lady. And I look at the probation's updated, and I hate to disagree with recommendations of the probation office, but I do in this case, and I do so respectfully, because I looked at the original pre-sentence report and the defendant's version where he tells the court that he's going to do excellent on probation. Said, I am just happy to be able to start over again. I hate that my kids see me in jail. I want to raise my kids like I was in a church and loving home. And then he goes and commits another offense, runs from the cops, chokes a lady that he's in a relationship with. And I just worry that his promises are just nothing but empty promises.
You missed the last sentence. I want to raise my kids like I was in church and a loving home.
Yes. Yes.
All those were wonderful words. That's not what I see in action, though. All of those are empty promises.
Just part of our job in doing justice is justice for the victims in these cases and protecting the public from people who just don't seem to get it. And the only way he's going to get it is if he has got more of a sanction than he's been getting. And I think he needs to be incarcerated. I think he needs to be placed in prison for the 6 years on the cap that I've given him, and ask that not only that, but that affirmative finding of a deadly weapon be placed in the judgment.
Mr. Samuel, on behalf of the defense.
Yes, Your Honor. We understand that the court has given Mr. Jones a second chance. We believe that if you look at what has happened and the sequence in which it happened, there's something more. We believe that there's a cognitive issue, one that deals with his inability to adequately deal with the stress that he's presented. And he made attempts to resolve that issue from his own assessment by way of getting counseling through a doctor online that gave him a prescription that we believe contributed to the episode. If you will notice, in the sequence of events, it's been a sequence of episodes, 2 episodes. Two after he had been placed on probation. And we believe that with adequate help outside, he can get that help. Now, he's been in jail for 4 months, and he initially wanted a bond. And as we discussed his issues, he said he realized he does have an issue in dealing with anxiety and stress. And that's what has led to the episodes, the 2 episodes that we see here. We believe that given the opportunity, he's accepted the fact that he needs mental health assistance. His family is contacted Spin on Top, and he's willing to go and get help in dealing with the stress and anxieties that he experienced. Now, I understand that there has to be some atonement for his actions. He's been in jail for 4 months. If given another opportunity to get professional help and he's successful with that, then that in itself would be the consequences of his actions. And he knows that in coming out, if he is allowed to remain on probation, he'd be facing a maximum of 20 years in prison. He understands
That's what he's facing now.
Yes, I understand. So he understands that. And he understands that the only way he's going to get through this whole episode is by adhering. And he did show probation early on that he could adhere to the rules and conditions. And it was a result of the later episodes, but that's no excuse. We simply ask that he be allowed the opportunity to go back on probation, even if it requires, well, we believe it should be on the high risk, high to medium risk caseload. We believe he needs to go through the cognitive program of the batterer's intervention. And we believe he needs to have professional clinical help in getting through this at his own expense. His family is willing to help him with the expenses of getting a doctor that can guide him through this. And we believe this would be an adequate way of protecting the public and being allowed to do better for himself. I can talk about the responsibilities that he has in having 8 children, but that's an issue he has to deal with. But we believe the basic source of his issues rely in his inability to cognitively deal with the pressures and issues that he's experienced in his life. So we're asking that the court give him that opportunity to get the professional help, remain on the high caseload, and if need be, ISF, go through that program and give him that chance to prove himself. And with that, I'd like to ask Mr. Jones some questions.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand.
Mr. Jones, we've counseled over the past couple of years, is that correct?
Yes, sir.
And you heard some of my frustrations early on.
Yes, sir.
And we talked about it. We talked about your thought process in trying to get your help through yourself by getting some doctor online.
Yes, sir.
Okay. And you also understand that didn't work.
Yes, sir.
And you understand that there is a need for professional help, clinical professional help
Yes,
with the doctor. And you've already talked to Spinal Top.
yes, sir.
And they are going to get you into a program there. So you do understand that there's a need for the system. That's all I have.
What doctor gave this diagnosis?
I don't know the name of it. It was a lady doctor.
I have the,
No, I want to know what the diagnosis was. Since I'm looking at 2 doctors of jurisprudence. There's not a medical degree in this group. I want to know who is the person with the medical degree who did the analysis.
Matthew Brumberry.
Let me, what do you have? Let me see. Wait a second. This is an evaluation from the Texas Cannabis Clinic. We're getting an evaluation on his cognitive behavior from the Cannabis
No,
Clinic?
no, sir. That's exactly what.
That's exactly what this is.
Your Honor, that is the mistake that I mentioned he made. That was the
The Cannabis
mistake.
Clinic. This is how much I give for the Cannabis Clinic. He's got cannabis issues.
Yes, sir. And that's,
Hold on. Who forced you at gunpoint to use marijuana?
Nobody.
Nobody. It's a free choice. You made the choice. Consistently, you made a choice. A free will choice. You get punished for making the wrong choices. When I hear something that shows he is under mental duress from a medical physician competent to make a diagnosis, let me know. Until then, it's a bad choice you made. It's been consistent. We warned you when we put you on probation in the first place. You had a cannabis issue then. You were in marijuana trouble. It's a free choice you made, like all illegal drugs. Even when somebody becomes addicted, they don't become addicted immediately. It's a series of bad choices, and you've had your hand slapped on it. Don't do that. Yet you go right back here's what we're dealing with now. This is behavior where when you put your hands around somebody's neck and squeezes, that's only one thing. That is an attempt to kill. That's what it is. You don't choke somebody, especially someone you claim you love. Mother of your children, or some children, I guess. But you're here for, let's see. The underlying offense was assault with a deadly weapon. I mean, this was a car driven into another vehicle, right?
Yes.
Intentionally. And so which is a 4,000-pound missile being used as a deadly weapon. And luckily, people were not seriously injured or killed. And you were placed on probation for that. And now you are strangling this woman.
And Judge, there is one other thing I'd like to point
Oh,
out.
God.
Back in May
Hit me with it.
of 2021, he was ordered to enter to successfully complete the anger management program, and he did, and he still commits this offense even after that. And he still wants to go back to more of the same thing over and over.
Look, your arguments are being made but without substantive backing from a medical physician that claims he's got a mental disorder.
Exactly. There are symptoms of,
I don't, you're a lawyer, not the physician, often.
I understand that.
Until I have a medical physician tell me otherwise, I've got 5,000 people who make bad mistakes on my watch. 5,000 people, and he's one of the 5,000. Some people are declared incompetent. Some people are even declared insane.
Mhm.
Until I can get a declaration of that, people are assumed to be competent and sane. They're also expected to follow the rules unless they are unable to because of a mental disorder, a personality disorder, or otherwise mental disorder. Until such time as I see that is not an excuse for bad judgments and anger management problem. Everybody gets angry. And we all grew up with people like that. They'll have a hissy fit and stop. And it's silly. It's like a little child. You have not grown out of that. Little children do that. But we grow up, we mature, and we move on. Some people don't mature. Some people feel that for whatever their personality is, which is not a disorder, nobody being perfect, but issues you have to address that you have to deal with so that you're not a danger to others as well as yourself, which you haven't responsibly done. And you've got responsibility. You got 8 children. So you quite naturally choked the mother after you tried to ram her on another occasion with a vehicle. And is it the same?
No,
No,
It's not. It's a different person.
different
Yeah.
person. Yeah.
Yeah. I mean, well, you've got 7 billion people left out there to harm, and we're not going to allow that. And your argument, it's on the record, but it's not supported by medical evidence.
He's been in custody for the past 4 months. Could we
156 days.
Could that be a part of, we
yeah.
request that would be.
He gets credit for all time he has served in custody in connection with a charge like this. He gets credit for it, but he's looking at, I'm sorry, this is 2 to 20.
Yes, sir.
He's asked for 6 years in prison.
That's what the cap was on the agreement on the MTRP, but he still got the other 2 offenses.
And
And there's an agreement that whatever sentence shall not exceed a cap of
6.
6 years. So I have up to 6 years, 2 to 6 years, or continuing them on deferred or unadjudicated probation. Those are the only options
I
I really
understand.
have.
so with that option of 20 years, we're requesting that he be allowed back on probation with the order to have assessments by a clinical doctor.
That should have been done earlier. If, as representing him, if that's what you wanted to do, that should have been done earlier.
But he's been in jail and he didn't have.
Yeah,
the
a
funds to get there.
doctor can be, you acquire a doctor, we can get him in there
Okay.
and they can analyze it.
Well,
Is that what you want?
yes,
Then we'll postpone this decision until such time that is done. I'll review it in 4 weeks. You
Yes,
got that much time to get
Yes,
a
sir.
position
yes, sir.
that is a competent position to go and analyze and do a report.
Shall do
Okay.
that.
All right.
Thank you.
This is, you stay in custody. You're not getting out for Christmas with misbehavior.
Dale.
Come on up. In front of this lady real quick. Thank you.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay, up to the right hand. Okay, so you're gonna place it.
Is Santa
flat.
coming to see you in your house?
I hope so.
Me too.
Okay, except for I won't be at my house. I'll be in a different state.
Would you be
but
so kind if you run into
Place
him?
it flat right there.
Remind him about coming to see me.
Oh, I will. He might just give me cold though.
24 CR 1662 is now called the State of Texas versus Eric Joseph Daigle. You are Mr. Daigle, present with Mr. Grove, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment? Can we proceed in summary?
Yes, Your
I
Honor.
guess we're just going on one.
Yes, sir.
Paragraph 1 alleges that on or about July 9th, 2024 in Jefferson County, Texas, you committed a third-degree felony of injury to an elderly individual. Do you understand what you were charged with here, sir?
Yes, sir.
If convicted, come on, you can do it. Come on, computer. You face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty and sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $1,000. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney. Are the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence
No objection.
without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record here for all purposes and without objection.
No objection, Your Honor.
Pre-sentence reports waived.
Yes, Your Honor.
Let me ask you real quickly, who is Clifford Thomas, the victim? What is his relationship to you?
Stranger.
Okay,
They're neighbors. They live on the same street.
okay, it's not a relative.
No.
No, sir.
I don't want, you can't have any contact with this person.
Yes, I understood it.
I'm going to find you pleaded guilty today voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this offense. You are hereby sentenced in accordance with this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That will be suspended. You were placed on regular probation for 10 years. You must pay a fine of $1,000. There will be other terms and conditions of probation, which are normal and customary for this type of offense. This was, how old are you, sir?
42.
Okay. Apparently, you injured and struck a 67-year-old man. They said the police saw him with a bloody nose and blood on the inside of his mouth. when you had a cut on your lower right knuckle. And a witness saw you strike the 67-year-old man with the right fist. And he fell to the ground. Why would you do such a thing? To an elderly person?
Actually, he had a weapon. He had a weapon in his hand, an object. And he stayed in an abandoned house next door to my house that's actually condemned. And it's like ongoing traffic of drugs and all kind of sort of things. And I actually approached him verbally and asked him, like on other occasions, when me and my kids are out in the front and they playing, could he not be like on those strange stuff watching my kids? And he got irate and did the belligerent with the weapon, and I just felt threatened. And I just struck him one time, yeah.
Okay. You see anything wrong with that?
Yes, sir, most definitely still.
Have you ever been assaulted or violent before?
Have I been assaulted?
No, have you ever been assaultive or violent before?
Not just physically, just probably when I was younger,
What do you mean?
like when I was younger growing up, I probably got into a scuffle before, you know. But just like naturally just looking for violence, no, sir.
You've got 2 convictions for robbery.
Yes, sir. But they wouldn't.
Yeah, that's a violent crime. 2 violent crimes. Did you forget about that? You can't even get probation from a jury. If you went to trial, they wouldn't, if they find you guilty, you go to prison, period. And this 3rd-degree felony would have been punished up to 20 years because of, if you were found guilty of this assault because of your prior convictions. Well, the point is what I'm saying is your violent assaultive behavior, which is what robberies are, you got 2 convictions. Punching out somebody, an elderly person, is an assaultive violent crime. You hadn't learned your lesson yet. How long has he been in jail? How long have you been in jail? A while?
Going on 2 months.
39 days.
You're going to do 180 days as a condition of probation. You know better than assaulting an elderly person after you got 2 robbery convictions. You punch him like that, punch him out. Sorry, as a condition of probation, you're going to serve 180 days. I'm going to give you credit though for time you have served. How much time?
39 days.
It's 121 days. Let's see, 180, 39, 141.
Judge Bobby Hurd.
141 days.
I'm not saying that they were justified back in, but his 2 robberies were back in 2007, which is sometime since then he has been able to stay out of trouble till this time. And obviously this is trouble. I'm not saying it's not. And he would not have pled guilty if he did not believe he was guilty. But I think that he has learned his lesson. And
how do you take the punch back from the old man? How do you pull that back and unvictimize him? He had a bloody nose, and
I'm not saying it was justified.
Well, until you can figure out how to do that, David, he's doing 180 days as a condition of probation because of his violent history. He doesn't have any business because he knows crimes have consequences, and he's getting probation here. What was your sentences on those robberies? Do you remember?
It's 5 years.
Yeah, you did 5 years in prison on each of those to run concurrently, right?
Yes.
So you went to prison for a violent offense. You come back, you commit a violent crime, and you're getting probation. See, some people might say, I thought things were going to, if you do the same type of crime, it should get higher. But that's not what we're doing here. We're giving you probation. But you still should know better. You know it has an accounting. And I feel sorry, not for you, for the elderly man who got punched. by you when you have robbery, when you have assaultive convictions. 141 days, you're given credit, 141 days confinement in the county jail is a condition of punching out the elderly man. His wife, you have prior convictions for robberies. That's only just. You can't go do that. You can't harm people like that, sir. Are you learning lessons here?
Yes, sir.
Okay.
My soul did.
Well, let's compose yourself better when you have to deal with issues and don't use violence. That's the third time you've been convicted of a felony of violence. Adria, that's all. Adria Richard, Dustin.